Okay, good morning class. My apologies for the delay, a little bit of a rushed up morning in Delhi here. Okay, so we're going to resume from where we were last time. We have completed the entire point about Article 116A, that is the powers of the Supreme Court in terms of hearing appeals. Right, this part we have covered. Power of the Supreme Court to hear appeals. Now, please can you just give me a sense of what all notes had we covered till yesterday? What all had I made you write till yesterday? If you can just give me an understanding of that. The notes that we had taken till yesterday. Can you please tell me the notes that we had taken yesterday? And if we are not in a mood to take the notes today already, we can take the notes later on. I can start with the next topic and we can cover the notes later up. Class, can you please tell me what are the last set of notes that we have taken up? Okay, disqualification is done, right? Okay. Disqualification of vacancy. Disqualification of vacancy. I think I've done the grounds for vacancy, not disqualification, under Article 101. Please tell me Article 101 is done or 102 is done. Okay, vacating seats in the foregrounds are done. Okay, so we can start writing with Article 102. Okay, so we can start writing with Article 102. Article 102, write down. Grounds for disqualification. Grounds for disqualification. Article 102, write down grounds for disqualification. Grounds for disqualification, write down. Grounds for disqualification. First, a person cannot continue as a MP, as a member of parliament. A person cannot continue as an MP, as a member of parliament, if he is holding an office of profit. If he is holding an office of profit. If he is holding an office of profit, comma, provided that, if he is holding an office of profit, comma, provided that, if he is holding an office of profit, provided that the office has not been exempted from this disqualification. The office has not been exempted, provided that the office has not been exempted from this disqualification. Office has not been exempted from this disqualification, by a law made by Parliament. Provided that the office has not been exempted from this disqualification by a law made by Parliament. Provided that the office has not been exempted from disqualification by a law made by the Parliament. Provided that the office is not exempted from disqualification by a law made by the Parliament. By a law made by Parliament. Full stop. Okay. Then write down the second round after this. After this, write down ground number 2. Disqualification for unsoundness of mind. Unsoundness of mind as certified by a court. Disqualification for unsoundness of mind as certified by a court. Disqualification for unsoundness of mind as certified by a court. Disqualification for unsoundness of mind as certified by a court. Unsoundness of mind as certified by a court. Okay, point number 3. After that, write down point number 3. Undischarged insolvent. Point number 3. Undischarged insolvent. Undischarged insolvent. Undischarged insolvent. After that, point number 4. Point number 3. Undischarged insolvent. Point number 4. Point number 4. Not a citizen of India. Not a citizen of India, or has adherence or allegiance to a foreign state. Not a citizen of India, or has adherence or allegiance to a foreign state. Adherence or allegiance to a foreign state. Not a citizen of India, or has adherence or allegiance to a foreign state. Not a citizen of India, or has adherence or allegiance to a foreign state. Okay. After that, next point. Point number 5. Disqualified by a law made by the Parliament. Disqualified by a law made by the Parliament. Disqualified by a law made by the Parliament, comma, under pursuit of which, in pursuit of which, Parliament has enacted the RPA 1951. In pursuit of which Parliament has enacted RPA 1951. Section 7 to Section 11. Section 7 to Section 11. Parliament has enacted RPA 1951. Section 7 to Section 11. Section 7 to Section 11. RPA 1951, Section 7 to Section 11. Okay. And then next point you can take a look at is anti-defection law under the 10th schedule. Anti-defection law under the 10th schedule. Anti-defection law under the 10th schedule. Okay, and then you can give RPA 1951, a heading, RPA 1951, disqualification. RPA 1951, disqualification, section 7 to section 11. RPA 1951, disqualification, section 7 to section 11. RPA 1951, disqualification, section 7 to section 11. Okay. RPA 1951, disqualification, section 7 to section 11. Okay, now write down the first point over here. Section 7 defines disqualifications. Defines disqualification. Section 7 defines disqualification. Section 7 defines disqualification. Disqualification as Section 7 defines disqualification as vacating the membership of a house immediately, vacating the membership of the house immediately, vacating the membership of the house immediately, of a house immediately, and not being allowed to contest elections. Being allowed to contest elections, not being allowed to contest elections, not being allowed to contest elections for a duration of time, for a specific duration of time, not being allowed to contest elections for a specific duration of time, not being allowed to contest elections for a specific duration of time, not being allowed to contest elections for a specific duration of time. Okay, not being allowed to contest elections for a specified duration of time. That is section 7. Okay, then after that, write down section 8. Section 8. Write down disqualification for committing offences. This is the title. Disqualification for committing offences. Disqualification for committing offences. This is the title of section 8. Disqualification for committing offences. Okay. Right. So now we move to the elaboration of section 8. Just write down over here under this, under the title, just write down a paragraph, disqualification for committing offences mein. Criminalization of politics, criminalization of politics has become a major concern. Criminalization of politics has become a major concern. Criminalization of politics has become a major concern. And the Parliament is empowered under section 8. And the Parliament is empowered under section 8. The Parliament is empowered under section 8. Parliament is empowered under section 8(2). Parliament is empowered under section 8(2) to create a list of criminal offences. A list of criminal offences. Parliament is empowered under Section 8 to create a list of criminal offences. A list of criminal offences, the conviction of which, underline the part conviction, the conviction of which can lead to disqualification. 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 Full stop. Okay, then change the paragraph and write down. Section 8, subsection 1 and 2. Section 8, subsection 1 and 2. Write down. Section 8, subsection 1 and 2. 1 and 2. Write down in this. Section 8, subsection 1 and 2. Write down under this. The Parliament mentions specific offences under these subsections. Mentions specific offences under these sections, under these subsections, which can lead to disqualification. Which can lead to disqualification upon conviction. Which can lead to disqualification upon conviction. Specific offences under these subsections which can lead to disqualification upon conviction. Which can lead to disqualification upon conviction, comma, which can lead to disqualification upon conviction, comma, examples are untouchability. Examples are untouchability, comma, communal hatred. Examples are untouchability, communal hatred. Cruelty towards women, etc. Untouchability, communal hatred, cruelty towards women, etc. Untouchability, communal hatred, cruelty towards women, etc. Untouchability, communal hatred, cruelty towards women, etc. Okay, fine. Then after that, put down the second point under this, section 8, subsection 3. Section 8, subsection 3. Please write down this one, section 8, subsection 3. This is a generic provision. This is a generic provision which which prescribes. This is a generic provision which prescribes. This is a generic provision which prescribes that an MP/MLA, an MP/MLA /MLC, an MP/MLA/MLC, an MP/MLA/MLC can be, MP/MLA/MLC can be disqualified if he is convicted for any offence. If he is convicted for any offence. If he is convicted for any offence and sentence for an imprisonment. and sentenced for an imprisonment of a minimum term of 2 years. Sentenced from imprisonment of a minimum term of 2 years and sentenced for an imprisonment of a minimum term of 2 years. Okay, and sentenced for an imprisonment of a minimum term of 2 years. Full stop. For example, full stop. For example, in the recent case of an MP from Wayanad, recent case of an MP from Wayanad who has been convicted of criminal defamation, and sentenced for 2 years. Who has been convicted of criminal defamation and sentenced for 2 years. Who has been convicted of criminal defamation and sentenced for 2 years was disqualified under this section. Section I mean subsection 8 subsection 3. 8 subsection 3. Minimum term of 2 years, students, minimum, at least 2 years and then above, okay, minimum 2 years. Maximum term of 2 years I was talking about in terms of defining the maximum punishment that can be given to defamation, okay, please don't be confused about this. When I talk about defamation, under section 8, when I talk about defamation under section 500, it says that the maximum punishment that can be given for defamation is 2 years. Okay. Now, when I talk about disqualification, it says that the minimum sentence required for disqualification is 2 years, right? So, in this sense, it is in a way converging with this, and that is why the whole thing comes as a set, that the maximum punishment for defamation is 2 years, minimum required under section 8 subsection 3 is 2 years. So, 2 years and 2 years come together, and hence the member of parliament is disqualified. Okay, please don't be confused about this. I have already stated this clearly to you. Okay. All right. Take. Then after that, you can write section 8 subsection 4. Section 8 subsection 4. Write down. Section 8 subsection 4. Under this section, section 8 subsection 4, under this section, it was previously mentioned that disqualification from an order of conviction, it was stated that disqualification from an order of conviction disqualification from an order of conviction, disqualification from an order of conviction will be suspended, will be suspended if an appeal is made from that order, will be suspended if an appeal is made from that order, if an appeal is made from that order, if an appeal is made from that order, if an appeal is made from that order. Within 3 months, if an appeal is made from that order within 3 months, within 3 months, within 3 months, full stop. This provision was struck down. This provision was struck down. This provision was struck down by the Supreme Court. This provision was struck down by the Supreme Court in Lily Thomas, in Lily Thomas versus Union of India, 2013. This provision was struck down by Supreme Court Union of India 2013. In Lily Thomas versus Union of India 2013. As ultra vires, comma, because it diluted the spirit of RPA 1951, because it diluted the spirit of RPA 1951. Because it diluted the spirit of RPA 1951. Full stop. Okay. Now, with regard to section 8A to section 10A, you will have to read directly from the RPA 1951 Bare Act. The notes are very simply, clearly given over there. Okay. With regard to disqualifications on 8A till 10A, you have to read directly from the RPA 1951 Bare Act. I've already displayed the Bare Act to you, and I am just going to very simply point out to you again how easy it is going to be to read from the Bare Act in that situation. Okay. Section 8A to 9 to 10, 10A, 9A, etc. All of these I think I have explained to you properly. You've taken a bit of a understanding of what we are in terms of the flowcharts, etc. we had drawn in the class. So you can take a look, just go to the Google search bar and type Representation of People's Act PDF 1951, and you will get this PDF and read section 8A to 10A, and that is something that you can take a look at yourself. Okay, you will not need to separately dictate notes upon these. You can write section 11 briefly. Section 11, just write down this briefly. Section 11, please write down. The offences you can write down for section 8A to 10A to be directly taken from the Bare Act. In section 11, in perspective of section 11, you can write down. Section 11, please write down. Election Commission of India, ECI, has been given the power. ECI has been given the power. ECI has been given the power to remove the disqualification and ECI has been given the power to remove the disqualification and or reduce the punishment. Remove the disqualification or reduce the punishment. Remove the disqualification or reduce the punishment. Remove the disqualification or reduce the punishment. Reduce the punishment. For all convictions under section 8 to section 10A. For all convictions under section 8 to section 10A. All convictions under section 8 to section 10A. Except for section 8A. Except for section 8A. For all convictions from section 8 to 10A except for section 8A. Except for section 8A. Section 8A, which lies exclusively under the jurisdiction of the High Court. Exclusively under the jurisdiction of the High Court. High Court. To declare a person involved in corrupt practices. Involved in corrupt practices. Comma. Involved in corrupt practices, comma. If such a disqualification happens, under section 8A, if such a disqualification happens under section 8A, the ECI, Election Commission of India, if such a disqualification happens under section 8A, the ECI, Election Commission of India, cannot remove or reduce the disqualification. Remove or reduce the disqualification or its duration. Remove or reduce the disqualification. Remove or reduce the disqualification or its duration. Remove or reduce the disqualification or its duration. Okay, this is section 11. So, taking a look at section 7 to section 11. Okay. Now we take a look at, now let's just, for some time halt on the note making process. It is something that we can take it on later on. It's kind of a repetitive, monotonous thing. Let me start with the next chapter, and I still have to give you the understanding of what happened in the West Bengal elections. So that is on my mind. Don't worry, I'll cover it out properly. Let me just, at this point of time, you can, just leave about 5 pages, 6 pages for the remaining notes on elections. Okay, the page 1, then the other side of that, page 2. Okay. So this is the first side, this is the second side of the page. So 1, 2, 3, 4, 5, 6. Just leave 6 pages. 1, 2, 3, 4, 5, 6. Right? So in total 3 sheets of paper and 6 pages of paper. Just leave them blank to cover the remaining parts of the election commission, elections, etc. And if I'm not able to give them all in writing in the class, I'll provide them the PDFs of this thing. Okay. So once we've taken a look at these things, let's take a look at the next chapter that I wanted to deal with in governance, which is transparency and accountability. Transparency and accountability. This is the next chapter that I want to take a look at in governance. Now, in transparency and accountability, I'll cover first the conceptual framework, in which we'll take a look at the concept of bureaucracy a little bit. We'll take a look at conceptual framework, in which we'll have the concept of bureaucracy. Okay. Then after that conceptual framework, we'll take a look at transparency, in which we will cover the most important part of the art for the governance paper, which is the Right to Information Act 2005. Then we will cover the Citizens Charter, and then we will cover e-governance. Then the next thing that we will cover in this is going to be accountability. In fact, accountability se pehle we can cover centralization. Centralization, decentralization. In this we'll cover the whole apparatus of schemes under the government of India. Yeah, due process of law and procedure established by law. ठीक. Kriti, I've taken a note of that. Okay, just let me, before I start, okay, Shiladitya, I can answer a question quickly. With regard to imprisonment, you're correct to say that many MPs stand for elections even when they're in jail. Let's take a look at this very simple thing. You can be imprisoned for, let's say for example, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10. 10 offenses under laws made by India. Let's say for all example, all the laws for the violation of which you can be sent to jail are 10 in number. All the laws, the violation of which, for which you can be sent to jail are 10 in number. Okay. Now, when we take a look at RPA 1951, Section 8. When we take a look at RPA 1951, Section 8, we are taking a look at, let's say, the Section 8 covers these many, but it does not cover 1, 2, 8, 9 and 10. You see the point? So, for these offenses would be considered of such a nature that a person can be disqualified. But he cannot be disqualified for all the offenses for which he has been imprisoned. Only the offenses which have been taken by the parliament in the RPA section 8 or 2 year wala jo example hai. Let's say for example, if a person has been punished for, let's say, imprisoned for 2 months for pulling a chain of a train. Okay. If he has been punished for 2 months for pulling a chain of train, then obviously this is not such a grave offense that a person should be disqualified from becoming a member of parliament, etc. Right? So similarly, a lot of people are going to be punished for a lot of offenses. The parliament has taken some of these offenses which are grave in nature, and it has given this kind of a delegation to the RPA 1951, which can be ground for disqualification. So insofar they are covered under RPA 1951 as grounds for disqualification, they cannot be taken, they cannot be, what you can say, they cannot contest elections. But if there are 8, 9, 10, 1, 2 other offenses which are not contained in the RPA, they can still be punished under they can still be punished, but they can not lead to necessarily disqualification. Okay, Shiladitya, is that the answer to your question? Okay. What is article, part, schedule, section? If possible, sir, please tell. I see many video but cannot understand. Please give a small brief understanding. Okay, fine. Let me just give you a simple understanding of this thing. Let's take a look at this. This is the Constitution of India. Okay. Constitution of India has what you can call things which are divided into articles. Let's say for example, if we talk about part 1 of the Constitution, we talk about part 1 of the Constitution, which includes article 1, article 2, article 3 and article 4, right? So these are all what are called articles, which are given in the Constitution. The term article is specifically denoted to refer to a number of, the division of the Constitution is done numerically, 1, 2, 3, 4, etc. And the prefix to that division is called an article for the Constitution. If, for example, you have something like the Indian Penal Code, instead of article, you have sections. So anything which is made by the parliament or which is a statutory enactment is known as a sections. These are referred to as sections. But since the Constitution is not made by the parliament, it is made by the Constituent Assembly, it uses a specific denotation for it known as an article. Clear? This is the difference between articles and sections. Okay, what else is there? Part. Okay, what are parts of the Constitution? Very simple. If you take a look at the Constitution of India, Constitution of India has been divided into parts. Let's say for example, what do you need to create a state? Okay, right? What you need is number 1, territory. You need territory to create a state. Okay. Number 2, after that you need population. Number 3, you need a government, right? And then you have these 3, for example, things which are given: territory. Let's say, for example, if I have to create a country, what do I need? Territory, people, and the government to govern the people. These are 3 things which are needed to create a particular nation. So part 1 of the constitution talks about territory. Part 2 talks about population. Part 3 talks about government. You see the point? Part 1 talks about territory, part 2 talks about population, and part 3 talks about government. Okay, let me, for example, elaborate this. Article 1 to 4, Union and its territory. Article 5 to 11, sorry, if I talk about this, Article 1 to 4, Union and its territory. Article 5 to 11, the citizenship, and Article 12, state. Similarly, part 3 can continue into fundamental rights, the rights for the citizens, especially in relation to the states. You will have, or rather, let's say, judiciary or independence of judiciary, which can take a kind of a separate view from the state, is given under Article 13. And then you can have the fundamental rights, which are given from Article 14 to Article 35. Right. This is part 3, and then there is part 4. Which is directive principles of state policy, which is Article 36 to 51. And there are part 5, which is, sorry, part 4A, I have missed out of it. Part 4A is fundamental duties, Article 51A. Right, and so on. You can have a look at part 5, which is the union executive, legislature, and judiciary. Then you have the state executive, legislature, and the judiciary, and the remaining part. So part is a kind of a natural, organic, and scientific division of the Constitution of India, which can be read in these aspects. Okay, just take a look at this. This is what basically parts are. Part 1 is territory, part 2 is population, part 3 is government, judiciary, fundamental rights, directive principles of state policy, etc., etc. Okay. कितनी देर हो गई? I'm sorry, there was some glitch with the mic here. Okay. Just let me see if you have understood the concept of the this part is clear over here. About the parts, I was mentioning the part 1 territory 1 to 4, part 2 population 5 to 11, part 3 government 12 and judiciary and fundamental rights, part 4 directive principle of state policy, part 4a fundamental duties. So it's a kind of a political science organization of something which has been given in the form of a document, which is the Constitution of India. So this is like a natural logical organization of the parts of the Constitution, one after the other in a chronology, right? It's a kind of a natural, like you see a territory is one, population is another, government is then, and etc, etc, right? So that's how you determine the differences. I was telling you about schedules when the audio went back, so I'll just repeat it again. See, let's say for example, if I am writing something of a will, if I am writing a will as a person who wants to give my property to my successors. If I am writing a will, a document which is supposed to give my properties to my successors, right? Now, within the will, I have, let's say for example, written the substantial portion of the will over here, okay? Let's say I have said that I will divide my property into 5 equal parts and give it to my 5 sons. This is what I have written in my will, that my property will be divided into 5 equal parts and be given to all my sons equally. Clear? Now, once this kind of a thing has been written in a will, then let's say I put a star mark over here and I say, for the details of all my 5 sons, please refer to schedule number 1. And in schedule number 1, let's say this is a document which is attached at the end of the will. I have details of my sons. Let's say for example, first son is Z, whose address is here, whose phone number is this, whose contact details are these. Second son is Y, whose address is this, whose phone number is this, whose contact details are these. Third son is this, address is this, contact details are this, right? So the details of something, a kind of a detailed document about some information which is relevant with regard to the subject that we're dealing with, is known as a schedule. So for example, you have the second schedule or the first schedule of the Constitution, which says India, that is the article 1 of the Constitution states that Bharat, that is a India, that is Bharat, is a union of states, right? And for a list of all the states, refer to the first schedule. You see the point? So the list and the details of something are attached towards the end of the document. You have the entire book written, and towards the end of the book, to have a kind of a separation between substantial parts of the book and the detailed parts of the book, you refer to the schedule, right? So schedule has a kind of a listing or an information which is detailed and is attached towards the end of a document. So that is what is a what you can call a concept of a schedule, right? So part, article, section and schedule, I think I'm making it clear to you. Let me address Kriti's question, which is about the procedure established by law and the due process of law. Okay, let me just give you a very simple analysis between the two. Procedure established by law and the due process of law. Now, I would want to, in a way, create a framework for you to understand this concept of the procedure established by law and the due process of law. Okay, so just try to be with me in this sense. Okay, let's say, for example, take a look at this. Let's say this is a person X. Okay, now X wants to wake up at 7 a.m. in the morning. X wants to wake up at 7 a.m. in the morning and study till 11 a.m. and then break from 11 till 1. Okay, 7 to 11 he wants to study, 11 a.m. to 1 he wants to break, and let's say 1 to 4 he wants to study again. Right, so what basically he's doing is preparing a schedule on the night before this day. Let's say this is a schedule for 25th December. This is a schedule for 25th December. So on the evening of 24th December, 9 p.m. okay, he's creating this kind of a schedule. And he's saying that I'm going to follow the schedule from tomorrow onwards. Right, that's what he's saying. Clear? Now, let's imagine that at 9 p.m. he gives this schedule to his father. And he says that please help me wake up at 6:30 a.m. My alarm is set at 6:30 a.m. but if I'm not able to wake up at 6:30 a.m., I will not be able to follow my schedule. But if I am, let's say for example, faltering upon, let's say if I am not listening to the alarm or something like that, if I'm unable to wake up at the right time, at the given time, then please wake me up forcibly. You know, no matter what I'm saying, no matter how asleep I am, please push me out of the bed. Okay, at 6:30 a.m. Very 100% clearly. So he gives it to his father. Okay. Now turning over to the next morning, right? His father wakes up at 6:15 a.m. in the morning and enters into his room at 6:30 a.m. and he starts waking him up. Okay. Now when his father goes to wake X up, X says to him that, Papa, please listen to me. I was not able to sleep all night. I was able to sleep at 4 a.m. in the morning. Something happened. I had a terrible headache, and I obviously did not think that the headache would be a thing that would happen to me suddenly. And for that reason, I could not wake. So I was all night listening to music or watching a movie to distract my mind, but I could not sleep. So I've slept at only 4 a.m. And since I've slept at 4 a.m. only, I at least want 5-6 hours of sleep. So please allow me to postpone my schedule from 7 a.m. to, let's say for example, 10 a.m. He says that I will start my day rather than from 7 a.m. to 10 a.m. So please give me these extra hours to complete my sleep so that I can at least be fresh if I'm studying. Otherwise, there's no point. If I wake up, I will not be able to focus on studies because I will not have a full night's sleep. Okay, look at this. Now let's say if the father tells the son that I don't care about anything, you made this schedule, okay, and therefore I am not going to listen to what you said. If you have not been able to make your schedule properly, if you did not factor in what could happen to you, you should not make such unrealistic schedules. You will make a better schedule tomorrow, but today you will have to follow this schedule, and whatever the mistakes of it, you will learn from it. We don't care. Okay, so you should be responsible in making a schedule clearly and properly. Don't try to change the schedule now. You have to go by the schedule. Wake up. You go through whatever pain and suffering you have to go through, but we don't want this to become a habit that you create a schedule and you start breaking it up, so that you get serious about making a schedule. Okay, you should have understood that if you're feeling a headache, etc., you should have made a little more relaxed and a better schedule. But now you get up, you can't sleep anymore, right? If I am, let's say for example, a father, who does that kind of a thing. Let's say a father says, wake up at 6 or 6:30 a.m. What I'm doing is I'm following a kind of a concept which is known as a procedure established by law. If I'm doing this kind of a thing, what I'm doing is following the concept of the procedure established by law. Just stay with me. Let's say, for example, if the father says that due to the new developments, okay, fine, I understand you slept at 4, fine, new circumstances have happened somewhere, things have happened which we did not factor in properly, and we are not able to find out the reasons for them, etc. So what we'll do is we'll change the procedure a little bit. We'll relax it and we'll modify it. We'll make it a new procedure, etc. Okay. If the father says that because of, let's say for example, if I have given this kind of a thing which has to be done, but something unexpectedly happens which is distorting this. So what I will have to do is I will have to make way for this by amending this. You see the point? If I do that, let's say you wake up at 10, you wake up at 9:30 and you start studying from 10 because something new has happened. This is known as a due process of law. You see the point? The difference between procedure established by law and the due process of law. Now, what am I trying to indicate over here? Let's say, for example, take a look at this. Article 21 of the Constitution state that a person's life and liberty cannot be taken away except by a procedure established by law. This is the most important reference which has been given in the Constitution of India of the concept of the procedure established by law. Okay. Life and liberty cannot be taken away except by a procedure established by law. Okay. Now, when we talk about something like this, let's say for example, if this is a person who is subjected to a law made by the parliament. The parliament has made a law. Okay. So let's say for example, parliament has made a law that every person appearing for UPSC must upload the final DAF by, let's say, N date. This is a procedure established by law. ठीक है, मतलब it can be the parliament or even the executive. Parliament is generally understood as the procedure establisher because by law means by the parliament. Okay. So let's say for example, if a law is made that a person who is preparing for UPSC must upload the final DAF by the N date. Okay, this is a procedure. If you want to appear for the UPSC examination or main examination or interview examination, you should have submitted your detailed application form by N date. Clear? Now, let's say for example, if a candidate is unable to upload the DAF by N date because of something inadvertent altogether. Let's say for example, he meets an accident or his village doesn't have internet or something which is, let's say, out of his control or out of his understanding. The question is, what happens in such a scenario? Now, if you take a look at the procedure established by law, it will not stop for anything to introduce a new factor inside the situation. It only says, the law says that this should be done by end date, and therefore it should be done by end date. No questions asked, no ifs and buts. Okay, but if there's a due process of law, it could mean that special circumstances or exception can be understood and be able to change the factorization of the situation. Okay, you see the point. The terms over here which are important are established. Established matlab it cannot be removed. Now let's say, for example, if the government of India, if the parliament or government feel that a lot of people are not able to fill their DAFs on time, then they should make a law again to provide different kind of extensions to the DAP filling application. You see, they should find, they should create different structures in which they can, you know, they should create exemptions by which people can become more relaxed and have, you know, extension. But unless a law like that is established by the parliament or the ministry, you will have to follow the law which has been established. We cannot stop the process in the middle of it for some person or individual. You see the point? So let's say, for example, if the government has made some very stupid procedure, let's say, for example, it says that everyone who wants an Aadhaar card must get his photograph without a beard. Okay, let's say it's a procedure which has been made. Now a lot of people are feeling that it is a violation of their personal liberty or life that you are being asked to trim your beard. Okay, but since the procedure for getting the Aadhaar says that it is something that is supposed to be without the beard, that procedure cannot be changed in the middle of it. It has to go to the parliament and change again. So you have to protest and pressurize your politicians to change that law. But let's say, for example, if an exception, if let's say I have given my Aadhaar application and I have made very many pains to get my Aadhaar registered, but my Aadhaar has been rejected because I'm wearing a beard and I was not aware of this rule, and I'm pleading that please you pass my Aadhaar in this special case because I did not know this was a rule that existed. In that case, it would be, say, procedure established by law. What is written in this as a procedural requirement cannot be changed. Okay, what is written over here as a procedural requirement cannot be changed, right? The procedure can be changed. Again, it can be established, but while this procedure is in place, you cannot change it, right? This is the meaning of the term established. When we talk about due process of law, okay, due process of law implies what is due. Okay, so the term due means over here that something which has not been taken into account. You see, for example, dues means something which is bakaya, which is not paid for, which is not accounted for. Okay, so for example, with due respect, which means that if there is any respect that I can't think of is available, or any respect that I'm missing out, I'm making a comment of saying that whatever respect is missing out, I'm paying you those respects with due respect, whatever respect you deserve and which I'm not able to see at this point. You see the point? So due means that something is due. Something can happen which has not been accounted for. Now, this is the point. Let's say, for example, if a person is filling a DAF and he has missed the nth date out of no fault of his own, and the UPSC says that your DAF will be cancelled, this person can go to the Supreme Court and say that please at least try to listen to the special circumstances under which I was not able to fill my DAF. You see the similarity over here with what you can see in the previous part. You had the question about what I'm saying is that the UPSC in this sense can be instructed by the Supreme Court to make an exception for this person, because it was not this person's fault that this kind of a thing had happened. So let's say, for example, in the case of the father waking up the son says ki just please listen to me, Papa, just please wait 1 second and listen to me, I have something to say. There was something which happened which could not have been avoided by me, and therefore the procedure should not be completely established, but it should be able to modify itself by factoring in something which was due, which was not something that we could account for in the instances, right? And that is why obviously you see that one of the most important aspects of due process of law is natural justice, and within natural justice also is the right to be heard. Right to be heard, that you have to, it's like the thing that please listen to me, at least give me one chance to say why I could not follow this particular aspect. That is what is known as a due process of law. You see the point? So let's say, for example, if a law is made by the parliament and the procedure is made by the parliament to support that law, that procedure under Article 21 cannot technically be challenged before the Supreme Court, because you cannot have a right to be heard in the procedure established by law. And this is exactly what was held by the A.K. Gopalan case in 1951, in which the Supreme Court said that procedure established by law under Article 21 does not allow the Supreme Court to interfere in the decisions taken by the Parliament in terms of procedure. So only the Parliament can change these decisions. The Supreme Court cannot make any amendments or any indications of these decisions, even if a personal liberty is being taken up, right? So in the case A.K. Gopalan, there was a question about preventive detention. Now, preventive detention law is made with reference to Article 22, and in that case, the Supreme Court was challenged by A.K. Gopalan, saying that the way in which he was detained was such that he was not given a fair hearing. That for example, they were thinking of him as a communist leader, and he was not a communist. He was trying to say, I am not the communist that you think I am. I am a different kind of a communist or a socialist. So the hearing that this person must be given was not given before detaining him. And he challenged the Supreme Court with regard to the preventive detention law, in which he said that my life and liberty has been violated. Supreme Court pointed out that life and liberty can be taken away by a procedure established by law, and since it is a procedure established by law, whether you were given a hearing or not with regard to your special circumstances is not going to be our business. And therefore, the Supreme Court did not take any judgment upon that. This exact case was overturned by the Supreme Court in 1978, Maneka Gandhi case, where Maneka Gandhi's passport was impounded by the Passport Authority of India for, let's say, for example, without giving her a hearing as to why she, let's say, for example, if you have not filled in some certain documents, etc., some date has been missed, something has been happened, right? The Passport Authority has automatically impounded a passport. Now, Maneka Gandhi said that I was not even given a fair hearing by the passport authorities. People said that due process of law mein hearing hoti hai, procedure established by law mein hearing nahi hoti hai. But the Supreme Court in this very case stated very clearly that if a person's life and liberty is being violated, procedure established by law must be just, fair and reasonable, right? Taking it closer to the due process of law. You get the point? So the idea of due process of law is that it is individual centric, that if a procedure has been badly drafted, the remedy according to procedure established by law is that you make the mistake, you learn from the mistake, and you draft a better procedure next time, right? You take the entire cycle, but you cannot stop the cycle in the middle. The logic which is given by the due process of law is that if the cycle, if the law is badly drafted or procedure is badly drafted, or it has some aspects to it which may harm individual liberty, then it is one thing to say that the procedure galti kar karke seekhega samaj, that's one thing. But second thing to say is that samaj ki galtiyon ka harzana individual nahi bhugtega, which means that the problems of the society will not be addressed by the individual. And therefore, to save the individual out of what is the law or procedure made by the society, there is a concept of due process of law. And a lot of people are in a way stating that the concept of procedure established by law in India has now started to look more and more like the due process of law. Many judgments of the Supreme Court have been stating that Indian procedure established by law can be read as a due process of law, and they have started including right to natural justice, right to being heard, and therefore people can go to the Supreme Court even today stating that the procedure by which the government has deprived a person of their life and liberty has not been just, fair and reasonable, right? So that's the point we can take a look at. In the original constitution, it was procedure established by law as held in the A.K. Gopalan case, but in the interpretations given by the judiciary recently, this has been changed to think of more as a due process of law. And of course, with regard to this, the judiciary has increased its power. Okay. So let me just give you a bit of a tabular analysis so that you can understand a little bit about it. Kriti, is it clear now, at least the conceptual part of it? Then you obviously can read your literature apart from what I am saying. Established by Parliament and cannot be questioned in a court. Established by Parliament and cannot be questioned in a court. Established by Parliament but can be questioned in a court. Established by Parliament but can be questioned in a court. Okay. Does not include natural justice. Includes natural justice. Like right to be heard. Does not include natural justice, includes natural justice like right to be heard. Okay. Is taken in the Indian constitution from the Japanese constitution. Is taken in the Indian constitution from the derived from by the Indian Supreme Courts as an inspiration from the American Constitution. American Constitution talks about the procedure established by law. Okay. And the case in reference to this is the A.K. Gopalan 1951 Supreme Court case. And the case in reference to this is Maneka Gandhi 1978 Supreme Court case. Okay, this is a kind of a simple tabular analysis to answer any question with regarding to procedure established by law in comparison to the due process of law. Now take a look at this please easily. Okay, I'll just take a little bit about the constitutional morality later on. Na? Let me just come back to the parts of governance. Is it fine? Kriti, do we have an understanding of the whole concept, procedure established by law and the due process of law in comparison to each other? Okay. Right. Now let me come to the point of transparency back. We are going to start on a very core concept of the governance chapter topic. So we'll take a look at it in a very conceptual kind of a framework. Okay, please take a look at the diagram that I'm trying to draw, right? And this is a diagram I'm trying to put as a conceptual framework of transparency and accountability, right? So we can give this as the starting of the chapter. We can write down, we are starting from here. Okay, conceptual framework. Please pay attention to what I'm indicating on the board. Conceptual framework. Okay, first, within conceptual framework, I talk about Weberian form of public administration, which is inspired by the great German sociologist Max Weber. And then I will take a look at second, democracy based public administration. This is also what we can take a look at term good governance. Some if you had the question about what is good governance, okay, so I'm just trying to get a sense in which we can take a look at these questions clearly. Okay, now these are the two things that I'm trying to cover up in this entire part. Okay. So let me just, for example, very structurally and categorically draw out for you what is the Weberian form of public administration. Okay, take a look at this. Now, okay, these are the people of a nation, let's say, for example. Okay, people of a nation through a process of elections. People of a nation through a process of election form what is known as a parliament. People of a nation through a process of election form what is known as a parliament, right? And let's say in for example, in the Indian ways of government, the government is formed out of the parliament. The government is formed out of the parliament. What does the government include? The government includes the prime minister, who is at the head of the council of ministers. This is what the government is. The government is formed out of the parliament. So basically what we have is that you have a majority political party in the parliament, and that majority political party within the parliament gets to form the government, right? So government is the prime minister and the council of ministers that are working under the prime minister. People, parliament, and government, right? Now let me just elaborate upon this. Let me take this example of government and establish it further. This is the Prime Minister. Under the Prime Minister are different ministries. Prime Minister is known as the head of the government, and the powers of the government are vested in the President, who is known as the head of the state. Okay, so you have the M1, M2, M3, M4, M5 ministries, which are headed by the Prime Minister, who is head of the government, and Prime Minister gets all the work done under the name of the President, in whom the executive power is, right? So Prime Minister and Council of Ministers take the decision, and the President is the one who signs upon those decisions. Okay, yeah. Anil, I'm just explaining that itself, Weberian model of public administration only I'm trying to take a look at. Okay. Now, till this point of time, you see, for example, if I take a look at this entire structure from here to here, let's take a look at this. If I take a look at this entire structure, this is what is known as the government. Okay, this is the government, and the government has a very clear overlap with the parliament. The government has a very clear overlap with the parliament. So, the president is both a part of the government and the parliament, and the Prime Minister and Council of Ministers are also a part of the parliament. They have to be members of parliament, as you have read in your polity classes. Okay. Now, what we are taking a look at in this regard is these areas let's say, for example, I call the Ministry of External Affairs as M5, Ministry of External Affairs. Okay, this is the ministry. The person who is in charge of the Ministry of External Affairs is the Foreign Minister. He is a person in charge of the Ministry of External Affairs, the Foreign Minister. Okay. Now, under the Ministry of External Affairs is going to be, or under the Foreign Minister is going to be, what you can call the Foreign Secretary. Under the Ministry of External Affairs is going to be the Foreign Secretary, and Foreign Secretary would be in charge of the administration of the Ministry of External Affairs. Okay, let's say, for example, under the Foreign Ministry you will have under the Foreign Secretary you will have joint secretaries. Okay, Joint Secretary 1, 2, 3 and 4. Clear? And let's say, for example, under the Joint Secretary 1, you will have the Department of WANA, which is West Asia, North Africa. Under the Joint Secretary, you have the Department of West Asia, North Africa. Okay, and under the Department of West Asia, North Africa, you will have certain countries. For example, you will have Iraq. Okay, you will have, let's say, Lebanon. You will have, let's say, Algeria. Right? Now, within these countries, there would be an ambassador to each of them, who would be representing the Indian mission in these areas. Okay, and within the ambassadors, there would be envoys, and within the envoys, there would be further down. Right? These are, for example, your IFS officers. Just take a look at this structure that I have created over here for your brief understanding. You see, the Joint Secretary of the, let me just take it from here. Okay, you have the people of India who through elections elect the Parliament of India. From the Parliament is formed the government. The government includes the Prime Minister and the Council of Ministers. Head of the government is the Prime Minister, who's doing all the executive actions in the name of the President, aid and advice of the Prime Minister and Council of Ministers. Under the Prime Minister are all the ministries, and under a ministry, for example, Ministry of External Affairs, this is how the structuralization of it happens. The Foreign Minister, who is in control of the Foreign Secretary, who is in charge of the public administration, who's in charge of these joint secretaries. Out of these, one joint secretary is in charge of the Department of West Asia and North Africa, and this joint secretary is in charge of these countries: Iraq, Lebanon, Algeria. Let's say one of the person is an ambassador in Iraq, and he is in charge of the embassy of Iraq, and then he is in charge of the envoys in the embassies of Iraq, and so on and so forth. Right? From here, let's say, for example, this division, the division which goes like this over here, this is the division between public administration and government. Okay, for example, what you have on this part, right? If I go north of this, this is all a part of what is known as government. If you go south of this, this is all public administration. Okay, this is where the two subjects in a way kind of diversificate from each other. Okay, this is the government and this is public administration. You see the point? Now, let's say, for example, I take these two things, government as X and public administration as Y. Let me draw out the new equation. Okay, just in case if you want to take a look at this chart properly, I'll just zoom it out a little bit. You can take a look at this chart. This is 1, people of India, 2, Parliament of India, 3 Government of India, 4 ministers, 5, 6, 7, 8, 9. Okay, let's try to follow these numerical patterns in terms of getting from one place to another to understand the structure of public administration. I'll just pause and just take a look at this chart properly. Okay, sound is back, I feel now. Okay, just take a little bit of a understanding of what I'm trying to say over here. Again, I'll start with this. I'm talking about X as a part in which you have a situation which allows us to understand the nature of the government, right? So for example, if I say 1, 2 and 3, you see, just try to understand the shape of this structure which is changing from 1 to 2 to 3. Okay, it is moving from the people to forming the government through the election of the parliament. Okay, so for example, if I take a look at X is the government and Y is the public administration. X is elected plus appointed, okay, and is a part of the democratic process. So all the ministers are For example, if you read about the Prime Minister of India, when you think about the Prime Minister of India, as it says in the articles of the Constitution, it states very clearly that the Prime Minister of India is appointed by the President. Okay, if you take a look at the Prime Minister of India, what the Constitution says is that it is appointed by the President. But also, for the Prime Minister to be appointed, a requirement is that he must be a member of Parliament. And then the political party which has the most amount of majority in the Parliament nominates a person who can be appointed as a Prime Minister of the country. Okay, so you have a kind of a person who is at the head of the political party, or in control of the political party, or in control of the member of parliaments in the Parliament, who is appointed by the President as a Prime Minister. So Prime Minister is fundamentally an elected candidate, but not only elected candidate to his own seat, but he has been responsible for the election of a lot of candidates in that house in which he is ruling. You see the point? And Prime Minister is the head of the government, and the Prime Minister then makes the President appoint the Council of Ministers, who are also supposed to be elected members of the Parliament. Prime Minister makes the President to appoint the other Prime Minister makes the President appoint the other cabinet ministers, Council of Ministers, who are from the Parliament, who are also supposed to be in the elected members of Parliament who can serve as ministers. So this is where the overlap of the Parliament and the government happens with the Prime Minister and the Council of Ministers and the President, who President, Prime Minister and Council of Ministers are both a part of the legislature and also a part of the executive. You see the point? That's the kind of a parliamentary form of government that India has chosen for itself. Now, once the ministers, etc., have taken their places, the ministers are in charge of the ministries. And then from the minister, the next position in every ministry is supposed to be the wedge between from the minister to the next post in ministry is supposed to be the wedge between the political master and the bureaucratic person, public administrator. You see the point? Now, political masters are all a part of the election processes, all of them. The bureaucratic people, the public administrations, are appointed. For example, the UPSC, when it takes the examination and it furnishes the final list, it says that the UPSC has recommended the following candidates. So people who fill up the spaces in public administration are not a part of the electoral process. They are not contesting elections to become members of the public administration. They are generally giving examinations to enter into these services, and then later on, for their promotions and appointments, they are dependent upon the political masters for their appointments. You see, so they are coming, both this part of state and this part of the state, the government and the public administration, both of them are coming from different sources. One is elected, the other is appointed. One is going through people and the other is going through a set of expertise upon certain subjects and then experience in public administration, and both of them come together and consolidate into one structure, okay, which is known as government and public administration. Generally also the entire thing is known as Sarkar, the government. Right. But if you take a block out of this and block out of this, you will see them very clearly distinct with each other. The minister and the what you can call the public administrator. And from the time that the Home Secretary is a minister, the person just in subordination to the Home Secretary and the most let's say powerful secretary in the Home Department is the Home Secretary. Right, and Home Secretary has control over the entire public administration system of India. That's how it basically, takes 1, 2, 3, 4, 5, 6, 7, 8 structures down to the last constable is under the control of the Home Secretary, who is reporting to the Home Minister, who is reporting to the Prime Minister, who is reporting to the Parliament, and Parliament is reporting to the people. Right, so this kind of a structure is something that the Indian government had chosen at the time, that you will have the Parliament 1, 2, 3, and then you will have the 1, 2, 3, 4, you will have the Parliament and the government, and 5, 6, 7, 8, 9 onwards you will have the public administration. And the sources from which the Parliament comes and sources from which the public administrators comes are going to be very different. One is going to come through an exam and then be promoted, the other is going to come to the people and be elected. You see, appointment and election. This is how this kind of a structure was supposed to create. They will both come together and meet at one median line and form a kind of a consolidation of governance, right? Now, one of the important things which were mentioned by Max Weber, and this is what I'm going to bring Weber in. Max Weber had said that public administration, okay, Max Weber had said that public administration and what you can call government are two distinct entities. He said that this is essentially a political entity. Essentially, this is the result of politics. And this essentially is a result of expertise. That is what he called it, the bureaucracy. Okay. And therefore, Max Weber said that these government should be under the control of the people, that people should be able to ask questions of the government, make the government accountable. If the government was not doing the right thing, etc., etc., it can do it. Okay. But the public administration should be insulated. Public administration shall be insulated from the people. That you must give very clear securities to the public administrators, that they should not be interacting directly with the people, and the people cannot interact directly with the public administration. You see, so this is coming from the people and is accountable to the people, coming from an expert kind of a criteria, and the accountability of the actions of these people, public administrators, is only going to be to their superiors, not to the people at large. You see the point? And in this regard, the concept that became relevant with regard to Weberian ideology was, number one, vertical accountability. This is the first feature of the Weberian model, vertical accountability. What it means is that, let's say for example, if this is a person who's working at the level of public administration, right? He has his superior, and this superior is reporting to a minister. Okay, so you have public administrator 1, public administrator 2, public administrator 3, who is reporting to the minister. Okay. Now, what this means is that if this is the people of India, okay, standing here, people of India can only extract answerability from the minister, but they cannot extract answerability from the public administrators. It will deflect back. You see the point? So, this layer of insulation, this layer of insulation was kept in the middle of the public administrators and the people in terms of interacting directly with the public administrators. You see the point? So, all your questions and all your doubts and all your complaints, etc., they had to be taken up with the minister who had been chosen by you and were accountable to you, right? So, the minister would worry about the political consequences of a certain action. Okay, let's say for example, if there's a thing which is happening with regard to what you can call let's say, a scam or a corruption in the government at any point of time at the level of, let's say, the district collector, the minister would feel the pressure of how it would reflect in the next elections. That kind of a pressure you can create upon the minister, but you cannot directly create any pressure upon the public administrators. Public administrators cannot be prosecuted for corruption in the Weberian model. Public administrators cannot be, let's say, terminated. They have permanent services, they have tenure, guarantees, they have remunerations and perks, etc., etc. So all of these things, the public administrators are given as a security of job and security of tenure, everything. They have a permanent residence, they have everything. And no matter what is happening at their end, they cannot do anything in terms of giving you an answerability or accountability to what they're doing. They're there to just do their jobs. And you are not supposed to, as citizens, give a feedback to them upon their jobs. Okay, you're supposed to be at the receiving end of whatever their performance is, and if you have any critical feedback, it has to be processed at the level of the minister, who can then, of course, put a pressure upon this entire structure and ask them to take a different position or amend themselves, etc., etc. So the question of what the accountability created by Max Weber, which was a kind of a thing that Indian government also used for some time, is the question of vertical accountability. That accountability goes from here to here to here and finally to the minister. Okay, this is the Weberian model. Now what we have seen, at least from example the 1990s in India after the liberalization, what we have seen is that this structure of vertical accountability is now not anymore the reality of Indian government. Now what it says is that there are going to be accountabilities not only at the level of the ministers, but also at the level of public administrators. Right? This kind of a structure has undergone a mutation very significantly under the new model of governance for India. That the mode of accountability, which was previously insulated towards vertical accountability, is now opening up at all ends. So for example, if these are the people of India, let's say for example, if this person is not satisfied by the work of this public administrator, okay, he will make a complaint to him, then he will make a complaint to him, and finally he will only get anything out of this public administrators in terms of exercising a horizontal accountability. Only a top-down force, a vertical accountability. Only a top-down force will work to make him work anywhere. Okay. But today what is happening in terms of the transformation in the governance model, which we are taking, the concept of good governance is what we are dealing with. Okay. Now these public administrators at their own levels are going to be directly responsible to their own people. Right? They will have to give answers, they will have to hold accountability, they will have to give information, and they will have to work together in coordination and cooperation with the citizens to achieve the ends of effective public administration. Yeah, brother, that's what I'm saying. The old model underwent a transformation to make all of this possible. Okay, now what you're seeing the DM is directly interacting is, I'm just giving a kind of a long-term 75-year view as a conceptual framework under which we will understand this kind of a situation. Okay, and that story that we have taken a look at is a story of the conversion of vertical accountability has ended in India. And it has been replaced by horizontal accountability. Okay, vertical accountability has been taken away from India and it has been replaced by what is known as horizontal accountability. You see the point? If we understand this kind of a conceptual background to what we are dealing with in this particular situation, we'd be able to manage a clear understanding of the questions with regard to the transparency and accountability part. Okay, so here I am dealing with the conceptual framework, and within the conceptual framework I am taking a look at 2 points. First, which is the Weberian form of public administration, which made sure that, see, let's say for example, if you take a look at in this chart, if any person over here, let's say if any person from here, down from here, is doing some kind of a badtamizi with a citizen, if any, let's say police constable does some kind of a rash behavior with a citizen, you know how the accountability was ascertained by the Weberian model? That you will have to go as a person to your MP, put some kind of a pressure upon the MP, who would put the pressure upon the government, who would put the pressure upon the ministry, who would put the pressure upon the department, who would put the pressure upon this person, and then this person could be persecuted, or a person could be actually, claimed to have been under some kind of a control. Okay, he can be disciplined. This was the nature of vertical accountability, that this person, let's say this public administrator, after having done something rash or misbehaving, said that I am not responsible to anyone except the person who is in charge of my affairs, except the office to which I report to. Okay, let me take a very simple example to elaborate this a little bit, tangible terms. Okay, let's say for example, if you go to a railway ticket office, and I don't know, we don't go anymore to the railway ticket office, but let's say if you have for example an experience like this, that you're standing in the queue for getting a ticket of Tatkal in the railway counter, and you see that the cashier is letting in some agents from the back door and is issuing Tatkal tickets to those agents, which means that, of course, that the cashier has some kind of a nexus with the agents, so that if they sell the tickets to some people, they will give some percentage of that nexus of that price to the cashier in cash. Okay, now you're seeing this through the window, and you're knocking the window door, and you're saying that you're objecting to it, that mujhe pata hai piche aap kya kar rahe ho, I know what you're doing over there, you see, and I will complain against you. That's basically what people say, right, when it is a kind of a situation in which you are dealing with public administration. I'm giving you a very simple everyday example of how people deal with public administrators, with sarkari people, right, that I'll make a complaint to you. Now, if it is a case of vertical accountability, the cashier will tell to you on your face कि जो करना है कर लो, जिसको complain करना है कर लो, you do whatever you want, we are not afraid of anyone. The cashier will tell you. You see why? For example, let's say if you take a look at a simple way of corruption, let's say you get a challan for crossing a red light or something, or not wearing a helmet. Now the traffic police person stops you and says, you say कि sir please don't make me play the challan, कहेगा कोर्ट में जाएगा, आपका गाड़ी कोर्ट से छुड़ा लेना, ये सारी चीज़ें. Okay, so you say for example, sir आप कुछ ले देके करो. Now let's say for example, if he takes 200 rupees from you, you see, out of the 200 he is only getting maybe 10 bucks. Okay, and the rest 190 are channelized upwards, to the point that the superior officers in that department are getting 100 rupees out of it. So every public administrator figure in the event of corruption is getting some amount of this kind of a bribe in proportion to their price, right? So he is only taking 10 bucks and he's cutting those 10s and sending out to the, so they have a kind of an organized corruption kind of a framework in which they take corruption money from the source of collection, and then they they collect all the money, and then they take the half that belongs to the local area, and then they send it upwards, and this kind of a thing circulates clearly and goes till the final position, sometimes even to the minister. So when the cashier, let's say for example, is doing some kind of a thing in which a Tatkal booking is happening and he is letting the agents inside, he is not the only person who is earning out of that corruption money. He is sending that package upward to his department. Now, in the case of vertical accountability, he is saying to you कि तुमको जो शिकायत करनी कर लो, मैं जो तुमको कर रहा, तो जो what you see that I am doing over here is actually planned by all of them. So they are not going to take an action against me. You see the point? So if the accountability is only to your superior, and the citizens, when they are seeing a blatant wrongdoing happening in front of their eyes, are helpless, this started becoming the problem in terms of how a government can be held accountable and can be held liable for its actions. A public administrator can be held liable for its actions. And in a way, this gave this kind of a chest thumping attitude to the government officers who were brazenly involved in corruption to tell you on your face when you catch them कि तुमको जो करना है कर लो, right? Because in terms of the linkage that was moving from vertical accountability, position 1, position 2, position 3, etc., it was all very well taken care of. You see the point? And that's why one of the important aspects of this is that the government was not exercising a direct accountability or answerability to people. The people at that point of time in the previous Weberian model did not have the ability to hold the collar of the cashier and say that I will get you terminated for doing this. They could not do it. They had no legal backing. They had no laws in favor of them. They had no orders from the Supreme Court. They had no RTI Act, etc., which would empower the citizens to do it at that point of time. Today, after this kind of a transformation has happened, we have broken the chains of vertical accountability and expanded it into horizontal accountability. That means that if a government servant is doing something now, there are enough statutes and laws, Prevention of Corruption Act, CBI, CVC, all of these things, the Citizens Charter, the RTI, all of these things are created to empower the citizens to hold the public servant directly accountable. You see the point? Without it going through that abstraction of going to the minister, etc. So that's the change in governance which has been one of the most significant transformations in India. And that's a story that I want to lay out in the conceptual framework. From the Weberian model of bureaucracy to a more what you can call democratic base of public administration, because later it was realized that democracy can not only be limited to elections. What it means to say is that just because you have good elections and then you have, like, say, the representation of the people is made in elections, doesn't mean that you can have a realization of democracy. Democracy cannot settle down after election. It has to keep its eyes open on the everyday activities of its government. Right? You know, see, the whole this quotation, the price of democracy is eternal vigilance, the keeping a democracy. So eternal vigilance means that you have to be always vigilant about what is happening around you in terms of the governance, etc. And cannot just rest upon your self if you have taken a democratic participation into elections, and that can be all that you want to achieve out of that. You see the point? So that's the point that I'm trying to, in a way, impress upon you with regard to this. Fine. I think I've exceeded a little bit. Let me take a break over here. We will resume in an hour and continue with this very exciting session on what is going to be the chapters about transparency and accountability, giving you some understanding of what is known as the vertical accountability and horizontal accountability. And then we'll take a look at the concept of transparency in detail. Right? And then we have to understand the instruments which have been given by the government and the parliament to us to ensure transparency and accountability. Clear? All right. I'll see you after the break. Thank you.